Okay, let's unpack this. When you look at the sheer stress people feel thinking about bankruptcy, um, probably the biggest single fear isn't even the filing itself.
Right.
It's the worry that they'll go through all of it, the whole process, only to hear, nope, sorry, no fresh start for you.
Yeah.
They're terrified they won't get that discharge.
Yeah, and that worry, it's completely understandable, but honestly, it's almost entirely misplaced.
Really.
Yes, the discharge, I mean, that's the whole point of the system, right? It's the legal mechanism that wipes away your obligation to pay most debts. It is that fresh start that Congress intended.
Okay.
And the key insight, really, when you look at the data and insights from folks like Francis Geraci, who've handled thousands of cases, is this. If you file honestly and you cooperate with your attorney, denial of discharge is, like, statistically tiny, negligible.
So that's the core thing we need to clear up for people listening. We need to look at what denying an entire case actually means, because it's super rare, and separate that from the fact that, well, some kinds of debt just aren't dischargeable by law. Doesn't matter how honest you are.
Exactly. Our mission today is basically to swap that anxiety for facts. We want to show you just how predictable and, frankly, safe the process usually is when you just follow the rules.
Okay, let's start with the odds then, because you said they're tiny. They sound pretty stunning.
Hmm.
If someone asks their lawyer, look, what are the actual chances the court just denies my whole bankruptcy? What's the real number?
Well, based on, decades of actual practice, the denial rate, it's somewhere around 1 in 100,000 cases.
1 in 100,000.
Yeah. I mean, just to put that in perspective, you're way, way more likely to get struck by lightning or, win a big lottery prize than you are to be denied a discharge just because the system felt like it.
Okay, so if honest people are safe, what are those 1 in 100,000 cases actually doing wrong? What gets you that kind of extreme reaction from the court?
They're typically involved in some pretty serious financial misconduct. We're talking active fraud.
Like what, specifically?
Like lying on the official documents, actively hiding significant assets, bank accounts, property from the court, transferring valuable stuff to relatives right before filing just to shield it. Or just flat out refusing to cooperate, refusing to show up for hearings, not working with their own attorney. The system is really built to catch abuse, not to, punish people who are just drowning because of medical bills or losing a job.
That really does put the fear of outright denial into perspective. A tiny box, really.
Mm-hmm.
Okay, so moving past fraud, the other big reason a discharge might not happen right away is timing. If someone's filed before, the rules are different. What's the waiting period if they had a successful Chapter 7 bankruptcy before?
Right. If you filed Chapter 7 and you actually got that discharge, Congress put in an 8-year rule. You have to wait a full 8 years, measured from the date you filed that first case, before you can file a second Chapter 7 and get another discharge.
8 years? Why so long? Sounds a bit like a penalty.
It's not really intended as a penalty, more like a safeguard. Congress wanted to prevent people from just constantly cycling through Chapter 7 year after year, using it like an annual debt cleaning service. It's about ensuring some seriousness and long-term intent.
Got it. And what if the previous case was a Chapter 13, the reorganization one?
That's actually much more flexible. The waiting period for getting another discharge after a 13 can be anywhere from 2 years up to 6 years.
What makes it vary?
It really depends on how much of the unsecured debt, think credit cards, medical bills, was actually paid back through that earlier Chapter 13 plan. If you paid back a significant chunk, the waiting period can be much shorter.
Okay, this flexibility actually highlights something really important about the system's value, doesn't it?
Mm-hmm.
Let's say someone is still inside that 8-year window from a Chapter 7. They desperately need help now. They can't get the full discharge yet. But filing a Chapter 13 still offers some immediate, pretty life-changing benefits, right? What are those?
Yeah, this is a crucial point people often miss. Even if that waiting period means you can't get the discharge today, filing of Chapter 13 instantly triggers the automatic stay.
And the stay is?
The stay is the court order that stops creditors cold. It means an immediate halt, so foreclosures, repossessions, wage garnishments, lawsuits, collection calls, everything.
Wow. So even if the final discharge is years down the road, they get instant breathing room, they can start catching up on the really critical debts like their mortgage or car.
Precisely. They get time. Time to deal with back taxes or catch up on mortgage arrears, all through a structured, court-approved repayment plan, something they absolutely couldn't do while creditors were breathing down their necks. The focus shifts, from immediate debt elimination to immediate stability. It lets them manage the situation legally without constant fear. That immediate crisis management, it's invaluable.
Okay, Let's shift gears then, because this is a huge area of confusion. We've established that denial of the whole case is almost impossible for an honest person. But people often mix that up with the fact that certain specific debts are just designed by law to survive bankruptcy.
Exactly.
And this is where it gets really interesting, right? A debt surviving bankruptcy is totally different from having your whole case denied.
Absolutely. It's a policy thing. The law basically decides that some obligations are just too important, either to society or because they're linked to bad behavior, to be wiped out no matter how tough your financial spot is. You can get your fresh start on, say, 95% of your debt, but these specific ones, they legally stick with you.
Okay, so give us the list. What are the standard debts that pretty much always survive and remain non-dischargeable?
Well, the big ones are, first, recent taxes, income taxes filed within the last few years, and certain tax penalties. The government usually gets its cut, especially recent stuff.
Okay.
Second, and this is the one everyone asks about, student loans.
Oh, yes, the big one.
Right. Now, technically, there are ways to discharge them if you can prove extreme undue hardship, but the standard is incredibly high. So, for the vast majority of people, student loans survive bankruptcy.
What about debts from, like, family situations?
Yep. Marital support obligations, so
Wow.
child support or alimony, those are always non-dischargeable, considered absolute social priorities. Then getting back towards that bad behavior idea, debts that came about because of actual fraud or theft or what the law calls willful and malicious injury, those are protected for the creditor.
Okay, willful and malicious injury. That sounds kind of legalese. Can you give us a concrete example, something that really sticks?
Sure. Willful injury means more than just, being careless, like accidentally bumping someone's car. It implies you intended the action or acted with real malice or maybe gross recklessness. Probably the most common example you see is a big court judgment resulting from a drunk driving accident.
Ah, okay.
Because the driver acted with such disregard for safety, any financial judgment against them from that accident is often considered non-dischargeable, even if all their credit card debt gets wiped clean.
That makes total sense. So fines and penalties owed to the government are out too.
Correct. Traffic tickets, government fines, court-ordered penalties, basically anything punitive or owed directly to a governmental unit. You can't erase those in bankruptcy.
Got it. Lastly, we have to talk about secured property.
Okay.
Houses, cars. This is where that difference between personal liability and a lien gets really important, right?
Yes, it's a bit nuanced, but critical to understand. Bankruptcy wipes out your personal liability for the debt, meaning the creditor can't come after you anymore for the money. They can't sue you for the balance. They can't garnish your wages for it. That personal obligation is gone. However, the bankruptcy itself doesn't automatically remove the lien.
Okay, explain the lien. Maybe use an analogy. What does that mean for someone who wants to keep their house or their car after bankruptcy?
Think of the lien like a legal chain that's attached directly to the physical the house, the car. That chain stays locked onto the property until the debt secured by it is fully paid off.
So you still have to pay if you want to keep it.
Exactly. If you want to keep the asset, you have to keep making the payments on that specific loan. If you stop paying, even after bankruptcy, the creditor can eventually use that lien to take the property back through foreclosure or repossession. Your personal responsibility for any shortfall might be gone, but the lien itself, it survives.
Okay, so the huge life-changing benefit isn't necessarily wiping out every single debt you owe. It's erasing that crushing unsecured debt. The credit cards, the medical bills, maybe old personal loans. By getting rid of that massive financial weight, you finally get the focus, the stability, the breathing room to actually manage the critical debts that legally have to remain, like the mortgage, the car payment, or child support.
That's precisely it. It's clearing the decks so you can finally breathe and prioritize what truly matters. Now, while denial is rare, we should probably touch quickly on who can actually object to your discharge and, why they might bother.
Right. Who are the main players who might raise an objection? And what gets them motivated?
Well, there are really two main groups. First, you might have an individual creditor object, but they need a really solid, provable reason, usually involving some kind of fraud or deception directly related to their debt. Like, say you maxed out their credit card buying luxury goods right before filing, clearly having no intention of paying it back.
Okay, that sounds specific.
It is. It's not common for individual creditors unless the fraud is pretty blatant. Second, and you see this a bit more often, is an objection from the U.S. trustee.
And the trustee is the government official who oversees the case. Their job is to make sure the system isn't being abused.
Exactly right. If the trustee suspects abuse, it usually ties back to something called the means test. This is the calculation that tries to figure out if a filer's income is high enough that they could actually repay a meaningful portion of their debts.
The means test. This is often misunderstood, isn't it? Like, the court is punishing people for earning a decent living?
It can sound that way, but that's not really the intent. How does the means test actually work? And what if someone listening does earn what feels like a good income, but they're still completely overwhelmed? Are they automatically considered abusive?
Yeah, are they?
Not at all. The means test is it's a very technical formula. It starts with your average gross income over the 6 months before you file. Then it compares that to the median income for a household of your size in your specific state. Then it allows you to subtract a whole range of specific, legally allowed expenses. Some are actual expenses, some are standardized amounts.
So the key is really in those allowed deductions.
Absolutely. What happens is this presumption of abuse usually only flags a pretty small percentage of filers. Typically, it's people whose income is significantly above the state median and who also have relatively low secured debt payments or other allowed deductions, meaning on paper, it looks like they might have disposable income left over each month.
But it's just a presumption. It could be challenged.
Exactly. It's just a starting point. And the source material, Geraci's work, for instance, makes it clear the law isn't meant to be punitive. We see cases all the time where households earning, well over $70,000, $80,000 a year successfully rebut that presumption. They show their actual legitimate expenses. They demonstrate, look, here are my real mortgage payments, my car payments, my taxes, my health insurance costs, maybe childcare. They prove that even with that higher income, their necessary fixed expenses leave them with little or no actual disposable income to pay back those unsecured creditors like credit card companies.
So you're essentially using the money that has to go towards those non-dischargeable or secured debts, the house, the car, to prove you genuinely can't afford to pay the dischargeable ones. That makes it sound much more like a math problem than some kind of moral judgment.
It really is mostly a math problem at that stage. If you can honestly show through your budget and documentation that you don't have the ability to fund a repayment plan, the system is designed to provide relief, usually through Chapter 7. It's not trying to force you into a Chapter 13 payment plan if your financial reality just doesn't support it.
Okay, this all just keeps driving home those two golden rules for success that Peter Francis Geraci emphasizes again and again: honesty and cooperation.
They really are your shield. The absolute biggest risk to getting your discharge, setting aside those timing rules we talked about, is deliberate dishonesty. Trying to hide assets, not disclosing all your income, transferring property sneakily right before filing. You're risking way more than just getting your discharge denied.
How so?
That kind of conduct, knowingly deceiving the court, it can potentially expose you to penalties for committing a federal offense. Bankruptcy fraud is serious business.
That's a stark warning. The system really is built to reward just being transparent.
It rewards transparency because the whole thing is based on fairness. The second you try to introduce deceit, you kind of break the foundation. The most practical advice from really experienced attorneys is always dead simple. Be honest and be organized.
Organized how?
Bring everything, every statement, every bill, every notice about any debt you owe. The more complete the picture your attorney has from the start, the better they can navigate the legal requirements for you and help ensure that smooth, predictable, successful outcome.
So wrapping this up, what does this all mean for you listening right now? It means that for the vast, vast majority of people, that fear of denial, it's really not something you need to lose sleep over. The process, especially when you're guided by an experienced attorney, is generally calm, it's predictable, and it's designed to give you the relief you need as long as you're honest and you cooperate.
Yeah, and the skepticism is totally understandable. People think, this sounds too easy, or there must be some hidden catch. But the legal reality, backed up by the actual data and decades of practice, is that the system generally works exactly the way it's supposed to. Denial is truly reserved for those really extreme cases, serious noncompliance, or outright fraud. For everyone else filing in good faith, the path to that fresh start is usually very clear.
And that really brings us to our final thought for you to mull over. Think about the moment you lift that overwhelming, just soul-crushing burden of unsecured debt off your shoulders. All those credit cards, the medical bills, maybe old loans, gone. Consider the profound shift, not just financially, but psychologically, logistically, that happens when you get that breathing room. Once that immense pressure is released, what kind of future planning, what kind of goals, maybe even ambitious ones, are you suddenly free to actually focus on and pursue?